Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers fruit of the poisonous tree, traffic stop risks, and consensual searches, and is brought to us by WLKY News Louisville's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, Surfshark. Surfshark is a premier VPN service that offers unparalleled digital security for a fraction of the price of other competitors. We all know that Surfshark is one of the most secure VPN tunnels on the market, but a Surfshark subscription also allows its users to bypass region restrictions on popular platforms like YouTube and Netflix and view content that's not normally available in your country. Thanks to Surfshark, I can still catch my favorite episodes of Friends, even though it was removed from the US Netflix catalog. A Surfshark subscription is totally unlimited, which means that you can use it on as many devices as you like, and even on all of them at once. No other VPN service offers that much accessibility. Right now, Surfshark is offering the ATA community an 83% discount with an additional 3 months completely free. With 24-hour customer service and a 30-day money-back guarantee, you have absolutely nothing to lose. On top of that, Surfshark is giving away their antivirus software completely free from now to the 4th of July. So, click the link in the description to claim your exclusive offer now. Thanks again to Surfshark for sponsoring this episode. On August 12, 2018, Louisville, Kentucky resident Anthony Parker Sr. was driving his girlfriend Demetria Furman's vehicle home from church, with Ms. Furman in the passenger seat and Mr. Parker's 8-year-old son in the back, when officers Kevin Crawford, Gabriel Hellard, Josh Dorr, and William Keeling Jr. of the 9th Mobile Division of the Louisville Metro Police Department stopped him for allegedly failing to use a turn signal, despite the fact that the body camera footage clearly shows that Mr. Parker had activated the turn signal and used it properly throughout the turn. Mr. Parker immediately pulled over, and the officers approached the vehicle from both sides.
What's up, man? How much how y'all doing today? I just leaving church? Yeah. Awesome, man. Good. That's awesome. Man, I'm sorry because you didn't use a turn signal. You was already over in the...
I got to do it like that for it's broke.
I got you. That's the reason why, man. That's the only reason, man.
Is that the only reason?
Do what?
Is that the only reason?
Yeah, just because your turn signal. Okay.
Okay.
Are there any weapons or drugs in the car or anything like
I
that?
just left church, got my son with me, my baby car.
So there's no guns in the car? Any knives?
No.
No narcotics like that? Awesome. Man, your hands are shaking like a leaf, brother. Even your faces. I just like people to be honest and straight up with me, all right?
Straight up.
Do you have your driver's license?
Yes, sir. My license is...
Okay, awesome.
I paid the reinstatement fee.
Yes, sir.
To take the license.
Is it? Okay, awesome.
I don't have no warrants. This damn signal.
Yeah, that's
It's
good.
working now, but...
I got you. Man, just do me a favor, put your hands on the steering wheel for me. Appreciate it. Man, before I have you exit the vehicle, do you have any weapons on you? Any guns? Awesome, man. That's what I'm mainly concerned about, all right?
Just left church.
Hey, I'm gonna get him out, I'm gonna get Dad out, and we're gonna go to the back, and then we'll get you out here in a second, okay? All right, man, when you exit the vehicle, keep your hands visible all times, all right? Don't put your hands in your pockets in the front.
I'm not, bro.
Go next.
Can I put my pants up, too?
Yeah, I'll get them for you. Okay. So nothing on you get in trouble, you might have a check real quick?
Go ahead.
Anything in the car gets you in trouble?
Man, nothing.
You need a mile with your check, right?
Man.
Appreciate it. Spread your feet a little bit more for me. Spread your feet.
Oh, yes, sir.
Thank you. All right, sir, we're just going to come back to the rear of the car.
After falsely claiming that Mr. Parker did not use a turn signal, the officer removes him from the vehicle and asks for consent to search him. Mr. Parker agrees, and the officer thoroughly pats him down and searches the contents of his pockets. The officer also asks Mr. Parker for consent to search the vehicle, but it is unclear from his response whether Mr. Parker was consenting to a search or simply telling him that there was nothing illegal in the vehicle. However, even if the officer received valid consent to search the vehicle, it is important to note that any evidence that was discovered from either of the searches would be inadmissible in court under the so-called fruit of the poisonous tree doctrine. As the Supreme Court explained in the 1984 case of Segura versus United States, quote, "The exclusionary rule reaches not only primary evidence obtained as a direct result of an illegal search or seizure, but also evidence later discovered and found to be derivative of an illegality or fruit of the poisonous tree. It extends as well to the indirect as the direct products of unconstitutional conduct." While there are exceptions where this doctrine will not be be applied, such as when the connection between the illegal police conduct and the discovery of the evidence is too far removed, or when the police also discover the evidence through an independent source, it is well established that any evidence discovered through a consent-based search during an illegal seizure must be excluded from court, absent the existence of an exception. For instance, in the 1983 case of Florida versus Royer, the Supreme Court held that because an individual was being illegally detained when he consented to a search of his luggage, quote, the consent was tainted by the illegality and was ineffective to justify the search. Similarly, in the 2008 case of U.S. versus Blair, the Sixth Circuit, which includes Kentucky, explained that, quote, an ordinary traffic stop by a police officer is a seizure within the meaning of the Fourth Amendment. Accordingly, any evidence seized during an illegal traffic stop must be suppressed as fruits of the poisonous tree. Here, the body camera footage clearly shows that Mr. Parker did activate his turn signal, making the alleged traffic violation that the officers claimed was the reason for the stop completely fabricated. Because the officers had no reasonable suspicion or probable cause to justify the traffic stop, any evidence that was discovered as a result of their search of Mr. Parker or the vehicle could be suppressed as fruits of the poisonous tree, even assuming they received valid consent from Mr. Parker.
Here, man, let's step on out real quick. You got your ID on you? You just leave it there, it's fine. It's over there. Step on out. Let's watch the sewer grate. Walk on back here for me. I'm gonna pass you down real quick. You got anything on you? Okay. Alright, spin around real quick for me. I'm gonna write down your info real quick, okay? Who's the gentleman in the car with you? Okay, alright. What's your last name?
Furman.
Last name is Furman?
F-I-R-M-E-T-R-I-A.
Okay. What's your middle initial? Yes. Birthday?
529.
9, your social? Okay. We do, this is how we conduct all our stops. We do so different type of unit that works a little bit different than a traditional stop.
While one officer talks to Mr. Parker, another officer removes Ms. Furman from the vehicle, pats her down without asking for her consent, and questions her. As we have discussed many times on ATA, the Supreme Court held in the 1977 case of Pennsylvania versus Mims that, quote, once a motor vehicle has been lawfully detained for a traffic violation, the police officers may order the driver to get out of the vehicle without violating the Fourth Amendment's prescription of unreasonable searches and seizures. Although the reasoning for granting this authority centers around so-called officer safety, officers are permitted to routinely remove both drivers and passengers from vehicles, regardless of whether they actually have any reason to be concerned for their safety. However, as the Supreme Court held in the 2009 case of Arizona versus Johnson, quote, to justify a pat-down of the driver or a passenger during a traffic stop, the police must harbor reasonable suspicion that the person subjected to the frisk is armed and dangerous. The Sixth Circuit has applied this precedent to many cases, and the court summarized its holdings in the 2021 case of United States versus Johnson, stating that, quote, an officer may stop a person based on reasonable suspicion of criminal activity, but to frisk him for weapons, the officer must reasonably believe he is armed and dangerous. The officer must be able to point to particular facts from which he reasonably inferred that the individual was armed and dangerous. Additionally, there clearly must be some nexus between the criminal conduct of which the police suspect the defendant and the aim of the protective search. This all means that a lawful stop does not necessarily carry with it the authority to conduct a pat-down search. In this situation, in addition to the fact that there was no legal basis for the traffic stop itself, there was absolutely no articulable evidence the officer could point to that would even remotely suggest that Ms. Furman was armed and dangerous. This means that even if the stop itself was lawful, the officer would not be able to constitutionally justify the pat-down frisk he conducted on Ms. Furman.
All right, big guy. Hey, I'm gonna have you hop out with Dad and everybody, okay? So hang out right next to him. Just hang out with Dad.
Despite the lack of clarity as to whether Mr. Parker consented to a search of the vehicle, the officers searched the entire car and the objects inside of it, including Ms. Furman's purse, without asking Ms. Furman, as the owner of the vehicle, for consent. In the 1974 case of United States versus Matlock, the Supreme Court explained that, quote, when the prosecution seeks to justify a warrantless search by proof of voluntary consent, it is not limited to proof that consent was given by the defendant, but may show that permission to search was obtained from a third party who possessed common authority over or other sufficient relationship to the premises or effects sought to be inspected. Applying this standard, courts have consistently held that the driver of a vehicle has the authority to consent to a search of that vehicle, regardless of who owns it. For instance, in the 2010 case of People versus Minor, the Supreme Court of Colorado noted that, quote, multiple circuits have applied this logic to vehicle cases in which the driver, who has common authority and a sufficient relationship with the vehicle, consents to a search, and ultimately held that, quote, a driver with control over a vehicle possesses the authority to consent to a search of the vehicle, even if the car owner is present as a passenger. Additionally, in the 1991 case of Florida versus Gimeno, the Supreme Court held that when an individual gives an officer consent to search a vehicle, the officer can also search bags or other containers if, quote, it is objectively reasonable for the officer to believe that the scope of the suspect's consent permitted him to open a particular container within the automobile. Therefore, if a court concluded that Mr. Parker did consent to a search of the vehicle, it would likely find that his consent was sufficient for the officers to conduct the search, despite the fact that none of them asked for Ms. Furman's consent, and that Mr. Parker's consent would likely authorize the officers to search most of the containers in the vehicle. However, because an officer cannot search an object on the basis of the consent of someone who does not have actual or apparent authority to authorize the search, a court could conclude that the officers did not have valid consent to search Ms. Furman's purse. As the Court of Appeals of Indiana explained in the 1999 case of State versus Friedel, where it held that a driver's consent to a search of a vehicle did not include consent to search the passenger's purse, which was left in the vehicle, explained that, quote, even though an officer does not have to obtain a separate consent to search each container found in a vehicle, an officer is still required to act reasonably when deciding whether the driver's consent extends to a particular container found within the vehicle. Because the officer who searched Ms. Furman's bag saw it in her possession and actually told her to leave it in the vehicle, it is likely that a court would conclude that he did not have consent to search it, even if the officers had valid consent to search the vehicle.
Everybody clear? Yeah.
I gotta double push my
There's
hazard light.
a lot of the Monte Carlos like
Yeah,
that, man.
I gotta
Really
double
is.
push the hazard. Like sometimes it'll work, you know, you hit it like normal. But then sometimes I gotta double push the hazard for the clicker to even come in. So that's probably what happened. Like I didn't even know I used it, but I didn't know it didn't come on.
Okay.
That's my
You good?
Yeah.
Sweet. All right, man. I'm not gonna harp on the OL or nothing like that.
appreciate it.
No problem, man. You guys are good to go.
All right.
After thoroughly searching the vehicle and finding nothing illegal, the officers allowed Mr. Parker, Ms. Furman, and Mr. Parker's son to leave without issuing a citation. On August 7, 2019, Mr. Parker and Ms. Furman filed a federal lawsuit against the officers, as well as the chief of the Louisville Metro Police Department and the head of the 9th Mobile Division. In the complaint, Mr. Parker and Ms. Furman's attorneys, who also represented Breonna Taylor's family, alleged that the 9th Mobile Division regularly engaged in deceptive and unconstitutional practices during traffic stops. For instance, the complaint stated that the officers conducted traffic stops in a manner designed to intimidate and trick the vehicle occupants to obtain their consent for searches and detentions by conducting stops with several officers in unmarked vehicles, boxing in the suspects' vehicles, surrounding the vehicle with several officers, accusing the vehicle occupants of appearing to have something to hide, and using quick double negatives to trick occupants into consenting to searches, as the officers in this situation did with Mr. Parker. On September 9th, 2021, the city agreed to the $75,000 settlement that allowed the Metro government to acknowledge no wrongdoing and prohibited Mr. Parker, Ms. Furman, and their lawyers from criticizing the Louisville Metro government or the police officers involved in the incident. In May of 2019, the Louisville Metro Police Department announced a complete overhaul of its traffic stop procedures in response to community criticism over a video of another traffic stop conducted by the 9th Mobile Division on then 18-year-old Tae An Lee, which took place on August 9th, 2018. 2019, just a few days before Mr. Parker was pulled over. Notably, the revised procedures prohibited officers from removing occupants from their vehicles and obtaining consent to search as a matter of routine. Overall, the Louisville Metro officers get an F for fabricating an excuse to conduct an illegal traffic stop, searching Mr. Parker and Ms. Furman and their vehicle without reasonable suspicion or probable cause, and using intimidation and deceit in order to obtain coerced consent from Mr. Parker. This type of police conduct is completely unacceptable behavior on the part of public servants and destroys the general public's ability to trust law enforcement. Although these practices were routine in the 9th Mobile Division prior to the procedural update, this does not absolve the officers involved in this incident of their personal responsibility for their intentional disregard for both the truth and the Constitution. This interaction highlights the counterproductive nature of certain aggressive police tactics, and there are many departments across the nation that could benefit from reevaluating their policing strategies. Mr. Parker and Ms. Furman get an A, because although Mr. Parker consented to the officer's request to search his person and possibly the vehicle, the couple remained calm and respectful throughout the encounter and followed up by taking appropriate legal action. Mr. Parker was faced with 4 aggressive officers who were determined to find contraband, and it is certainly understandable that he agreed to be searched when he knew he had nothing to hide. I do not know what was going through Mr. Parker's head during this traffic stop, but I would imagine that he chose to consent to the officer's request at least in part out of concern for the well-being of his family, and I certainly cannot fault him for prioritizing his loved one's safety over his constitutional rights. I commend Mr. Parker for remaining calm and collected throughout the encounter and for following up this interaction with the proper legal action. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.